So thank you to everyone to be here and welcome to this first month of our Web3 Cardano Legal and Regulatory Bootcamp. I'm very excited to have you here as we embark on this journey together. So my name is Matthias Traussnig. I'm Swiss qualified lawyer since 2017, and I'm currently working at Storm Partners, an important, well-known Web3 consulting firm that is organizing today this event that is hosted by Decentral House, the first hub, Web3 hub here in Geneva. So in the past, I worked in many different law firms. I am a Swiss qualified attorney since 2017. I have also worked at the prosecutor office in Geneva for more than 2 years and almost 2 years at Deloitte Legal in Geneva as well. In addition, and this is the reason why I'm here today, I'm passionate about crypto, and I've been involved in the crypto space since 2016. So I'm quite old in this space, and I'm quite familiar, let's say, with the crypto industry and its codes. Some people are watching this in real time. Thank you, but please be informed that this presentation is also recorded, so you can watch it later. If you have any questions, feel free to ask them after this presentation, of course. In addition, even after the end of the presentation, you can contact me directly or someone from the team by email, LinkedIn, or Telegram, or as you want. Our legal team will be pleased to support your project. So about myself, I am currently at Decentral House, and for this presentation, I will share my screen so it will be easy for you to follow my explanations and comments. So I will do it now. Okay, could someone please confirm that you can see my screen?
Yes, it works.
Perfect, thank you, Johan. It's not the first screen, let's go to the first screen. So today we will talk about security and utility tokens. And let's move directly to the second slide of the presentation related to our program of today. Firstly, as you know, it has been said in the last presentation, but to be sure we are aligned, please note that this month of May, we are dedicating our effort for supporting Web3 entrepreneurs acquire the foundational legal and regulatory knowledge necessary to establish and maintain strong business. In my personal view, understanding the legal and regulatory side of things is crucial, I think. Of course, I'm a lawyer, but it is not the only reason. I think it's important for the success and sustainability of any of your project, in particular in the Web3 space, which can evolve really fast from a regulatory point of view as well. And this legal mount is structured around 4 comprehensive masterclasses to allow you to get the knowledge to firstly, understand the most relevant legal issues for Web3 projects. Then, secondly, be able to assess the legal setup of your project, understand how works fundraising through token sales and the common contracts used in the Web3 space, as well as the risk associated with not complying with applicable law and regulations. So today I want to introduce and discuss with you the different characteristics of tokens, how to qualify them, and the potential legal implications. In particular, we will focus on utility and security token, which trigger a lot of different regulation requirements, but we will discuss that a bit later. Indeed, we have decided to focus on tokens. I think that everyone is aware that tokens are really important and is one of the core of the blockchain mechanism and become more and more regulated. Indeed, about their functions, token can firstly facilitate decentralization and mass adoption. So they are really important when you have a project. Furthermore, tokens also power smart contracts, automating and enforcing agreements on the blockchain, avoiding to give the control on transaction to a third party. So it's quite something really important. It's quite linked to the use of the blockchain. And finally, and it's, I think, most really important for projects from a non-tech side, tokens can play a vital role in financing projects and creating robust incentive structures. They allow projects to raise funds through token sales, giving early support to project and help support project to be successful. So it's why I think token is important. And as you know, a lot of projects are using tokens for staking and reward. For example, it's an incentive. It helps the project to have active participation and contribution from users and developers. So it's important. As a result, I'm going to remain, I will try to stay this presentation should be really accessible. So it's easy to understand for you, even if there really are some technical sections from a legal perspective. Because I know when you are not a lawyer, sometimes it can seem easy for me, but it can be more complicated for entrepreneur. And it's really the goal here to be precise and for you to have an overview of what is really to have an impression of the legal aspects. So let's start with our today's topic. So on the right of this slide, you have the specific list of topics that we will be discussing today. So we will start with the practical comments related to tokens, then the characteristics of tokens, the approaches in different jurisdictions, so the different kind of approaches, legal implication for your business, the trends and recommendation that we as legal specialists, we can give you, and we will finish with a case study before the conclusion. So the first point, so the practical comments related to tokens, clarifies tokens and highlights the implication of various factual elements such as the applicable law or the impact of the project's nature. As practitioners, we have noted that entrepreneurs that come to us to receive advice often have questions related to tokens. And here we will use this expertise to give you some detail on specific points that are really important for people that are coming to us. Then after we will focus as deeply as possible on the characteristics of tokens. In our view, the tokens characteristics are the starting point for a legal assessment. So we need to qualify the token. It's really important. Here we will examine the different types of token that exist in different jurisdictions and the factors that determine the legal type of token and how the type of token can be altered. Then the third point, we will give the importance related to the nature of the token. We will check the different legal frameworks that exist with a focus on the differences between important jurisdictions. Understanding these differences is vital, I think, as the regulatory landscape governing tokens varies significantly across countries. The goal here is to provide you with a comprehensive overview of the variations among jurisdictions. Of course, I cannot cover all jurisdictions, as you know, but this will help you to understand how issues can arise and why you should be careful. The next point, we will be building our discussion of legal framework. This section focuses on the direct legal consequences for tools dealing with tokens. Indeed, it's interesting to know that you don't have the right to do something, but what is really important is to know how to comply and what is the consequences. I mean, for a project, if the project doesn't comply with the legal requirement. And of course, we'll give practical advice to help your project to have a successful income. In particular, we are going to take a look to the Ripple case, XRP case. I think that some of you are aware of it. This case has impacted the token's value and led to a very important procedure in the crypto space that was a lot followed. Then I will continue this presentation with the trends and the recommendations that we can give you. That's important to give you some input from the practitioner that we are. And to wrap up this presentation, we'll examine together a case study that shows a potential problem that can arise. This will help me to illustrate what I will explain in the next slides and show you how fast a problem can emerge and if or not it's possible then to settle this problem. I hope that everything is clear, and I will move to the next slide related to the practical comments on the topic we are discussing today. So, as mentioned in the previous slide, the first crucial point in the legal landscape of token is their classification. As you can read here, tokens can be categorized. They can be categorized into various types, such as utility tokens, security tokens, and payment tokens in Switzerland. Each kind of token is subject to different regulatory requirements. So we have 3 types. I didn't put it here, but we have utility tokens, security tokens, and payment tokens. But you will have a slide that show you that coming from FINMA, the regulatory body in Switzerland. So proper classification is essential to defining the applicable legal framework and compliance obligations. This is very important for 2 important reasons in my point of view. So firstly, security tokens are typically subject to restrictive securities regulations. So a security is a financial instrument. And when a token is a security, the legislator decides that you must absolutely comply with the law related to the investment, the financial investment instrument. So it's important, and at the opposite, utility tokens may fall under less rigorous regulation. This is the case, for instance, in Switzerland. So understanding the classification is really, really the starting point, and you must really be careful with this. So to give you an idea of the 3 main categories in Switzerland, first we have the payment token. These tokens are intended to be used as a means of payment for getting goods or services. They are subject to AML, anti-money laundering regulation, but are not considered securities. So they are not subject to securities regulation. Secondly, the utility token. This is the second category. The kind of token provide access to a service and are not treated as securities. However, of course, you must check if the utility token is also an investment token, and then the nature could change. And then we have the third kind of token, the asset token. These represent assets such as, for instance, participation in real physical assets, real assets, companies, or earning streams. In addition, there can also be an entitlement to dividends or interest payments. So you can really see that asset tokens are related to financial instruments. What is really important is to assess if your token or not is an asset token. In the EU, so here it was about Switzerland, but in the EU regulation, the regulatory landscape will be guided by the Markets in Crypto Asset Regulations, MiCA law. This upcoming regulation will take effect in a few months at the beginning of next year, and will classify token between utility token, so we have the same conception, asset token again, and e-money. E-money is related to the payment token that I mentioned before. In the US, we have only 2 main categories, I would say. The Securities and Exchange Commission, called SEC, generally classifies token into 2 categories: securities tokens or utility tokens. And to decide if this is the case or no, we have a system. The system is called the OWE test. This is often used to give you an overview of what is this test. The OWE test is a legal test used in the United States, and you have some special criteria that you follow or not. So firstly, the OWT check if your token is a financial investment for a participant. This is the first point. Then this test is checking if the investment is in a common venture, typically involving pooling of funds. This is the second point. And then if there is an expectation of profit from the investment. Of course, you can note that this is really broad categories, and then you have some slight nuances, and it can be really tricky to determine if yes or not a project you invested, I don't know, 1 year ago, because they were doing an IDO and the project was not completely finished, if this project is if the token of this project would be qualified as a security token. The second point, so here you have an overview of the classification that we can have. I focus on United States, Europe, and Switzerland. Then what is really important, and I think you already understood that with what I explained with the OWT test, what is important is the function of the token. So yes, what is crucial in all these jurisdictions regarding function is that the token's concrete function will determine at the end the classification. For instance, even if a token is labeled as utility token, I don't know, on your website or in a white paper, if the token's function are related to an investment or represent an underlying asset, it will certainly be qualified as a security by the regulatory body and be subject to corresponding regulations. So it's not important how you call your token. What is really important, it can be important, and I will explain that in the future, but it is not because you call your token an utility token that it will be a utility token. Therefore, in our point of view, understanding the actual use case and economic reality of the token is essential to ensure the legal compliance of your business. In addition, please note that a token can have multiple classifications depending on the context. Of course, if the token has the security classification, the token should be comply with the regulatory requirements of the concerned jurisdiction. And the last point, last but not least, the classification can evolve over time. So it is not because at the beginning of your project you went to a lawyer and the lawyer said that your token is a utility token. For instance, the regulatory body confirmed that. It can be the case in Switzerland, but it doesn't mean that your token will never be will have another type. The nature of your token can change. About the determination of the token, one essential point is the way the project communicates. I mentioned before that it's not because you called your token a utility token that this token will be an utility, but the communication is important. Indeed, the effective communication about a token purpose and characteristic is critical. If a token is marketed or described in ways that emphasize potential profits or investment returns, it might be classified as a security, even if it was, I don't know, in the project clearly intended to be a utility token. For instance, yes, to give you an example, promoting a token and highlighting its potential, I don't know, to make money as the project will grow and can lead regulators to treat it as a security, in particular in United States. We will discuss the XRP case after, but yes, just this really quick example shows you the importance of being careful, precise, and communicate as well as possible about what you want and what is your project. Of course, I know that sometimes we are running after money, and in particular for entrepreneurs, it's important to get some traction. But yes, at the end, it's important to be fair and to say what we are doing. Otherwise, your token could be qualified as security, so as investment token, and then you will have to comply. So it's not a problem, just to be clear, that your token is a security, but it means that you need to follow a special path that I will illustrate later. To avoid this and to be really clear in what you are doing, from my point of view, you should use a relevant methodology. So it's the next point here to determine what is the classification of your token. For instance, you could do the following first analysis. The first step is to understand the token's intended function and characteristics by understanding the technology, the use case, and the economic model underlying the token. So it's really factual. Then I think you should research the regulatory framework in relevant jurisdiction you target to go. So you want to put your seat or you want to target with your project, or to deal with the jurisdiction where you have your seat. Of course, this includes understanding how different countries classify and regulate tokens, and it can be complicated. And it's absolutely possible to ask to a law firm or a consulting firm specialized in Web3 to do that for you. We can do, for instance, a legal memo to understand that. Then when you have these two elements, I think you can determine the token's classification based on its function, rather than its name, and you can decide and you can check if the token function is the same in all the jurisdiction you are targeting. For instance, as you may know, in United States, they have another approach. I will talk about it later, but yes, they have a restrictive approach and you can easily be qualified as security, and it's not necessarily the case in other jurisdictions like Switzerland. And then the last point, and I think it's important, and it's related to the previous point, you should develop a communication strategy and be careful how you communicate. This strategy must accurately reflect the token's intended function and what you plan to do. Please, and I want to say that again because it's really important, avoid making statements that could imply the token is an investment or promise financial returns unless it is intended to be classified as a security in your project. This can be really dangerous for you. Last but not least, I mentioned that after, if you modify your roadmap in your project, please be careful, and maybe it's time to go to your lawyer or to assess your project to be sure that your token is still a utility token, if this token was an utility token at the beginning. The next point is about tax implications. So I am not a tax lawyer, but to advise my clients, I have some legal tax basis. And I think indeed it's important for you to be careful with the tax implication. Utility tokens, for instance, provide VAT. It's really important for VAT. Typically, you must be careful because VAT, yes, you can VAT can really change the nature of the tax. You can have to pay VAT. Sorry, I lost where I was in the slide. In the opposite, security token represent ownership or a stake in an underlying asset, company, or revenue stream. In the tax practice, transactions involving security token are often subject to capital gain tax. So it depends, but if you have to summarize a utility token, you will have to pay VAT. But if you have a security token, you will have to pay, for example, capital gains tax, and it can be higher. This is what I wanted to say. And yes, I'm not a tax specialist, but you understand, I think, the basis. Last point on this slide is the emission and distribution. Finally, the emission and distribution of token can vary significantly depending on the type of entity involved, such as associations, foundations, or companies. This is more an organization matter perception, and it can also be, again, a tax purpose. To start, we have three types, I think, of entities here in Switzerland: association, foundation, and companies. Associations are typically non-profit entities. And this can be interesting because you can benefit from the status of non-profit organization. And you can have, for instance, low tax rate. And it can be important for VAT as well, or this kind of thing. It's basically the same for foundation, but the structure is a bit more complex for foundation, and you have it will take more time, and it's a bit more complicated to have a supervisory authority in Switzerland. So, but it's the same. It's almost the same principle. And company, I don't think I need to introduce you how work a company. What is really important here when you have a company, you must know that you will have potentially to pay more taxes than if you have a foundation or an association. Of course, it's possible to have complex structures involving the above entities. It's totally possible. We are doing that at Storm. For instance, you can have a company in an offshore jurisdiction, and the foundation related to the company can be in Switzerland. This is possible. You can also have some companies or entities in offshore jurisdiction. Basically, you can do what you want. I mean, if you comply with the law, but it's possible to have many different kind of structures. We did that, we are doing that, and we did that a lot in the past. We have a lot of experience. And at the end, what is important is what is your goal, what you want to do, because a lot of people are sometimes talking about the BVI or other offshore companies, but it depends. It really depends what you are doing, where, if you have employees, where are the employees, where is the board management as well. So it depends on a lot of criteria. Switzerland is well seen in the world. Maybe it can be more complicated if you go to the BVI to open a bank account and I don't know, to raise money. It depends. So you have a lot of criteria, and we are pleased to advise on this. Let's move then to the next slide, which is related to the characteristics of tokens. So I already mentioned the classifications, but generally speaking, countries have their own regulatory framework. For example, in the US, the SEC is using the OE test that I mentioned before. In EU, you will have the MiCA regulation that is coming in a few months. And it's really important to understand where you are and what you are doing. So the key steps include, first, determine the jurisdiction where the token will be issued and traded. Identify the relevant regulatory bodies. So in each jurisdiction, you must be careful and know who is the regulatory body, the SEC in the United States, the FINMA in Switzerland, and ESMA in Europe, for instance. And then outline internally the current and planned activity of the project to ensure compliance with the regulatory framework. This is the theoretical point of view. But what is important, I think, is the practical point of view. Indeed, you should analyze what the project is currently doing and what it plans to do. Assess the current use case and functionality of the token is really important. You must also evaluate future development and expansion that might alter the token classification. I mentioned that in the previous slide. And develop a strategy to comply with changing regulation as the project evolves. From a practical perspective, you should engage, I think, with a technical person to really understand. If you're a lawyer, so the lawyer should engage with a technical team or the CEO, or I don't know, to really understand what we are doing. So I suggest to firstly work with technical experts to assess the token's underlying technology and the practical application. So you understand you don't need to do it, and you don't have to be an expert in this area, but you need to understand what you are doing. Then how the token is used with the user basis. I think it's really important. And then the practical implementation, and to be sure that this implementation is aligned with what you want. Of course, in the practical world, the implementation can differ significantly from theoretical plans. For instance, you can have, at the beginning of your project, a white paper, and you decide then that it doesn't reflect what you want to do or the current market, and you decide to change a bit. And here, this is here that you must have, and this is the reason why it's important to have a really good understanding on what you are doing right now, because if this is the case, you must have a light in your head saying, we need to be careful, maybe the nature of our utility token is changing. Given the complexity involving token, because here I give you some principle, but of course it can be really tricky, and the difference depends how you communicate, how you structure your project. Your token classification can change. It can be advisable to obtain a legal opinion, and so it's beneficial for your project. From a professional point of view, we have a lot of clients asking that, and it's really well seen from a potential investor who see that you are really careful with the regulatory, what is happening, and you want really to comply with the law. I can give you maybe a concrete example on how it can be tricky and how your token situation can change. For instance, if a token issuer allocates a fixed percentage of its revenue, I don't know, to fund buybacks and burning token, this could be viewed as an indirect distribution of profits to users, investors, and such actions could be considered as a instrumental financial instrument, and you would have maybe to pay. Your token will be classified as security, and you will need to comply with this law. Indeed, the expectations generated by the buybacks and burning are crucial to the potential requalification, because people will expect to have this, and will maybe buy your token because they know you are doing this action. This will raise the price of your token, but this price will raise because you are doing this act. And this is the reason why there is a good chance that an authority like the SEC will ask you to pay, will consider your token as security, and you will have, I mentioned, to pay, because you will have certainly to pay a fine, and you will have, of course, other regulatory requirements to meet. So in Switzerland, something that is really interesting is that we have the concept of no action letter from FINMA. The FINMA is the regulatory body, and this body is really involved in the crypto space. You can talk with FINMA, and it's quite impressive how fast you can get an answer from them. They have some legal specialists knowing the topic, so it's great. But of course, the no action letter is related to a really specific project, and if your project changed, the no action letter is not valid. To explain you quickly, so a no action letter, you explain what you are doing, and then based on your explanations, the FINMA can say, okay, we consider that your token is your utility token, but this is only based on the facts that you bring to FINMA. So then if you change your project, you modify a bit your project, FINMA could say, yes, we consider your token as utility token at the beginning, but now that you are doing something else, it's not the case anymore, and you cannot put yourself behind the fact that you have a no action letter for your project. I think we can go directly to the next slide. This slide is related to the difference between legal framework in different jurisdictions. Understanding the difference between the various legal frameworks for token is, in my point of view, essential for ensuring that their issuance and management comply with relevant laws and regulations. I have already introduced the type of token and give you some insights about how this can change, but some specificities in the legal jurisdiction, you have some specificities in the legal jurisdiction between countries, and this should be highlighted. So to give you an overview, We have United States here, Europe, and Switzerland. The Europe is working toward a standardized approach under the markets and crypto asset regulations, which will be enforced in a few months. But what is interesting, and I want to discuss this a little bit, it's the US situation, because it's often that in a project, we decide to US investor or the US jurisdiction is excluded when you do, for instance, an IDO. And in practice, US are often excluded for various reasons. Firstly, the SEC applies rigorous standards. I already mentioned that. The OA test, which is quite general, is applied, but really in a strict way. So a token could rapidly considered as a security token. And secondly, we have a potential legal risk and uncertainties for projects if you go to US. It's again related to the SEC approach, because if the SEC considered that, I don't know, after 3 years, your token is a security token, it means that you didn't comply with the law for the last 3 years. And of course, you will have penalties and a lot of problems. About Switzerland, so I am based in Switzerland. I can tell you a bit more. So Switzerland is quite crypto friendly in our point of view. You have the FINMA that I mentioned before. FINMA has issued comprehensive guidelines on initial coin offering and token classifications. These guidelines provide clear criteria for categorizing tokens as payment, utility, and asset token. I can already show you. I can go on this slide, which is the next, so you can see this is directly from the FINMA guidelines. FINMA, so these guidelines has been issued in 2018, so more than 5 years, almost 6 years now. And FINMA is quite experimented to dealing with token sales, and is proactive as a proactive approach for related to the regulation. We have also a DLT Act, which is quite important. The DLT Act is related to the Distributed Ledger Technology Act, and so it helps you to qualify what you are doing, the action you want to do, if you want to launch an exchange, for instance, or I don't know, the token. But this act show as well, and it's the reason why Switzerland is well known. A lot of projects like Ethereum or the Cardano Foundation are in Switzerland, because you have a stability here. And you can see that with this first guidelines, which was in 2018. So it was really early. And in this guideline, it's FINMA really explained what you can do and what is a payment tokens. So this is the slide. What is a payment token? What is a utility token? And the asset tokens. About Europe, so prior to the introduction of the MiCA regulation that is coming, the regulatory landscape for tokens Europe was really fragmented, can we say? Indeed, each European Union member state had its own approach to classify and regulating tokens, leading to, of course, significant variability and complexity. And this is why now you have MiCA. The goal of MiCA was precisely to explain what to have one similar approach in the country. Of course, you can have some different application rules, but the approach will be similar. Because at the beginning, tokens that were classified as security might be different from a country to another country. And this is the reason why FINMA MiCA, the European regulatory body, decided to adopt MiCA to really have a framework and to really explain what is crypto, what is a utility token, what is a asset token, and what is a e-payment token. The goal is to harmonize the regulatory framework for crypto assets across EU, providing clarity and consistency. And what is great also in this law is the fact that MiCA provides clear guidelines for security tokens, aligning them with existing financial instruments regulations. This includes comprehensive requirements for issuance, trading, and custody, for instance. MiCA was a bit criticated from the crypto space at the beginning because you have, yes, regulation for the security, and now it's clear what is a security in MiCA, but you have also a regulation related to the utility token and the crypto assets token, the e-payment. And this is the reason why this was criticized at the beginning, but I don't think that it means that it's a bad law. But now the rules are really clear in Europe. I can maybe, so I don't know if you had the time to read this slide. So this is the first example that explain precisely what is payment tokens, what is utility token, and what is asset tokens. I let maybe 20 seconds to let you read this slide. And then I can go directly to the next one. I will let you a bit of time to read it as well. It concerns the qualification as security and the legal consequences that you can have. The FINMA, basically what the FINMA did, so in the previous slide, they explain what are the three different kind of tokens, and here they explain what is the consequence if you have an asset token and what you should do. And of course, it's just one of the different sentences that you have in the guidelines. You have 20 pages or 120 pages. And here, this is just an example, but it shows you how precise FINMA was 5 years ago to really have a framework, a legal relevant framework for investors and projects in Switzerland. Let's move to the next slide related to the legal implications for your business. I think it's a really important part because now we define what is a security token, what can be what, but we didn't discuss what can happen to your project if, I don't know, you qualified a security token as utility token, and then the regulatory body is coming to you. So if a token is determined to be a security, there are several significant legal implications for the issuer and the platform dealing with these tokens, in particular in jurisdictions with well-defined securities law, like United States, Europe, or Switzerland. And here is I noted a list so I can give you some problem that you can have. The first one, or the legal implication that you can have. So the first one is the registration requirements. In many jurisdictions, securities must be registered with the relevant finance regulatory authority. For instance, in the US, security needs to be registered with the SEC unless a specific exemption applies, which is generally not the case for a crypto project. And this involves detailed disclosures about the company's operation, financial condition, risk factor, and management. This is the first one, so the registration. The second point is related to the disclosure obligations. Issuer of security are required to provide comprehensive information to potential investors to make informed investment decisions. These include ongoing disclosure obligations such as financial reporting and disclosure of material events, which could influence the value of the securities. I think it's quite aligned with the practice of different countries, because if your token is qualified as security, it's a financial instrument, and it's normal that you need to disclose of information. Then another criteria that you have is the compliance with the securities laws. The security law can be different from a country to another. I could talk a bit more about the Swiss security law, but you have another one, of course, in the US. MiCA is also different, but the bases are the same. You are subject to strict regulatory requirements regarding the issuance, trading, and overall market conduct. You cannot do what you want with your token, and you need to follow precise rules. This includes adherence to anti-fraud, for instance, or anti-manipulation provision to protect investors. Then you have the prospectus requirements. In places like Switzerland, the issuance of asset tokens that are classified as securities will necessitate a prospectus compliant with the Swiss Code of Obligation and the other relevant securities law applicable in the jurisdiction. This is not something that is complicated, but you need to do it. The point of this prospectus is to provide information about the investment offer and the issuer, and you must do it. The idea is to protect the consumer, the retail, for instance, and people investing in your project. You could have also market restriction. Indeed, being classified as a security can limit the trading venues where a token can be legally traded. Securities typically require trading on a regulated exchange or platform that have specific licenses to handle securities trading. So this is another point. You must be aware of that. And then you have one other point about the liability. You could have liability if you fail to comply with regulatory standards. So you as a person of the company could have a liability, and you could also have penalties that can include fines, injunctions, or even criminal charges. I won't talk about this today. I did a presentation last week about the potential criminal violation that you could do. But yes, you must be aware of that. And of course, the last point is related to the investor rights. You must respect your investor, and you must really, yes, be careful to not to meet the rights they have. This is really important. So this is the requirement. So it's the first point about the consequences. Non-compliant with securities regulation can have several consequences for a project and for token issuers as well, and user of the platform. So these consequences are related to the project, so the people in the management. The first one is fines and penalties. Indeed, regulatory authorities can impose substantial fines and penalties for failing to comply with the registration and disclosure requirements. You can also have some seize orders. Authorities can issue seize and desist orders, stopping, for instance, the sale and trading of the token. It can happen. It didn't happen in the past, but it could happen. You could have some court injunction, criminal charges as well. Lawsuit against investor who suffer, for instance, for losses due to non-compliance or misleading information can file a lawsuit against your project, against you, for compensation. And then you can have reputational damage. Of course, this is not good if, I don't know, you have some media coverage and the media say that you qualify your token as utility, it's a security, and you could have a big potential fines and penalties. These will have consequences on your project. But yes, it depends on the jurisdiction and the approach of the regulatory body. But to illustrate the above, I think it's the moment to talk, to go to the third point and to talk about a famous case known as Ripple against SEC. I'm quite sure you know this case, but in short, to give you an overview. So Ripple Labs is a company behind the cryptocurrency XRP that is in the top 10 on crypto market. Ripple has been in a legal battle with the US Security and Exchange Commission, so the SEC, since December 2020. So it's more than 3 years now. And the SEC filed a lawsuit against Ripple, alleging that XRP is an unregistered security and that Ripple conducted an unlawful securities offering by selling XRP without proper registration. So this is really the basis. The SEC main allegation is the fact that yes, they did that, and so the SEC is claiming to Ripple that Ripple raised over 1.3 billion through the sale of XRP, and XRP consider that this is an unregistered security, and according to the SEC, Ripple should have registered these sales under the federal securities law. So they have to pay a fine, and there is some penalties to be paid, as well as other potential sanctions. In addition, the SEC claims that founder of the project personally profited from the unregistered sales of XRP, so they have also potential consequences against them. You have this personal liability rule that apply. Right now, even if the case has not fully concluded with ongoing disputes about specific details and implications of the court's ruling, Ripple achieved a partial victory. Not definitive, it's a partial victory, because the court ruled that while institutional sales of XRP violated securities law, it was not a real security. It was not a security, and it cannot be considered as a security. The distinction is significant, and it's really narrows, I can say, the scope of the SEC. But as mentioned, the process is still ongoing. The allegations are still maintained, but yes, SEC cannot say that XRP is totally a security. It's not possible. What is important to say about this, and then I can move to the next slide, is the fact that this case was closely watched by the cryptocurrency industry, because it will set a legal precedent for how other cryptocurrencies are classified under US law, which is crucial in law. Indeed, it will be possible then for the SEC to take advantage of this case to go after other projects. So it was really closely watched, as mentioned, and a decision classifying XRP as a security could have significant regulatory implications for the whole cryptocurrency world, I believe. And now the process is ongoing for more than 3 years. So we had some debates. The XRP, the Ripple asked to get some access to SEC documents. So it's really interesting. And we can really, in this case, see what is the SEC approach, what they are arguing, how they are arguing. And we can see really that the approach is really restrictive. And if XRP will be considered as a security, you can have the same problem with other projects. Now we come slowly to the end, but before going to the case study, it's important, I think, to discuss the trends and recommendations related to the current crypto market. So governments and regulatory bodies around the world are increasing the regulation of the cryptocurrency market. This is a clear trend that I want really to highlight here. In particular, this trend aims to protect consumers, prevent fraud, and ensure financial stability. Key examples include the SEC, for instance, that we mentioned, that step up against unregistered securities offering. there is some rumors that SEC will start other lawsuit against other project, and you have also the MiCA regulations that is coming in a few months. In addition, you have there is a growing trend toward global regulatory coordination. You can see that organizations like the Financial Action Task Force are setting international standards for AML measure that countries are highly encouraged to adopt. So you have really this idea to collaborate in the space, in the financial area, but also in the Web3 area. Then you have the adoption of comprehensive frameworks. MiCA is just not just a small regulation, I would say. MiCA is well drafted, or anywhere MiCA is really precise, and so it gives a lot of information what you can do and what you cannot do. Now you have less uncertainty than in the past. I strongly believe. So for a project, I think today what is important for your business is not to be too cautious, but to be aware that your token can be qualified as a security, and to know in which space you are and what you are allowed to do and what you are not allowed to do. That is really fundamental in my point of view. What is also important is to choose an optimal jurisdiction. It's maybe not the best idea today, for instance, to launch your project only in the United States and to have your headquarters of the company in the United States as well. It's not. It can be maybe a better idea to go to Switzerland, which is known for its stability and the guidelines that you have and the supportive regulatory environment that you can have as well. What is also important, in my point of view, is to stay informed on regulatory developments. Indeed, you have a lot of evolution in the United States, in Europe, in Switzerland, and in various jurisdictions. And you must be aware. It's really important. It can be yourself, or you can be in touch with a lawyer, a law firm, a consulting firm. It is really important to be aware that this is not because, I don't know, in 2020, your token, you could do something. This is maybe not the case anymore. It's exactly what is happening in Europe. In some country, you had a really broad approach, and now you will have certainly next year a restrictive approach because you have MiCA coming. You have MiCA coming, and countries will have to comply with MiCA. Then another point, another advice that I want to give you is to engage with regulatory bodies if possible. So I know that, for instance, in the United States, it's really complicated to discuss with the SEC. A lot of companies like Coinbase or Ripple complain with this. But if you can, for example, it's the case in Switzerland, it's really important to discuss, to get a license or to get a no action letter, to discuss with the FINMA and to be open to explain your project and what you think. And then I started the presentation with this. It's important in my point of view, and it's crucial as well to understand the core business you have. It's essential to clearly understand and define the nature of your token and the role within your business model. This includes knowing whether your token might be or will be qualified as utility token or security token or payment token, and ensure that your business practices align with this clarification. This clarity helps in maintaining compliance and aligning with regulatory expectations. So that's it about the recommendation that I could give to you. Now it's time to move to the case study. So this case study is in 3 different parts. I let you maybe read the first part. Then I move in, I don't know, 30 seconds to the second, and then to the last part before giving you the resolution. I hope you had the time to read this first part, and I'm moving now to the second part. Here you can see that they raised 30 million from investors. And then this is the last part. I think the most important elements in this case are in this last part. So as you can see, the main facts related to our case study concern the marketing. Indeed, the campaign point out potential investment return, suggesting that the value of the token utility X will appreciate as the platform is growing. This is the first point, sorry. And then you have some promotion material. You have in promotion material the fact that holding UTTX tokens will entitle investor to a share of the profit for the platform, leading to dividends, of course. I think this is the most important in this case study. And so about the resolution, firstly, the promotional campaigns emphasizes on investment returns and profit sharing, and this can mislead investor into viewing the token as investment opportunity rather than utility token. This is the first point. In addition, highlighting future growth driven by the management team implies that the token's value depends on the effort of others, which can align more with the characteristic of securities that we discussed in this presentation. So in my point of view here, just because we have this marketing communication and users and potential buyer of this token saw this marketing communication, the token could highly be qualified as a security token. Despite maybe it's really a utility token, but the marketing is really important. Indeed, investor purchase token with the expectation of making a profit. For instance, the profit were to come from a common venture, UTTX platform, and investors are led to expect profit from the platform. So you remember maybe we talked at the beginning of the presentation about the test that can be made by the SEC. Here you have of course, the conditions are met. And yes, you don't need to have all these conditions. Just if one condition is met, you have potentially you have a security token in the SEC's perception. About the consequences, I think we already discussed that in a previous slide, but yes, you could have some fines, you could have some penalty. The board members could have a liability as well. You will have probably some reputational damage if you have a procedure against you. So you have many types of damage, and of course, there is a big chance this procedure is open against your company that the price of the token will dump. So it is clearly a possibility. So it can be really dangerous. And even if you raise 30 million at the end, you can have huge problems for your project. So I believe it's time I'm already speaking for 1 hour. It's time for the conclusion. I strongly believe that to implement efficient token tactics in your project is important. And it's essential for these two reasons. Firstly, you must do that to understand what you are doing. And secondly, you must do that to anticipate the project future application, development, and communication. So you know exactly what you are doing. And if I don't know your roadmap is changing, you know it, and you know that potentially you could fall into the scope of the security law. And it is really important. As usual in law, it's great to go to a lawyer when you have a problem, but anticipation is key. I think, as mentioned in this presentation, we are drafting, for instance, legal opinion. We are advising even in a 1-hour call clients, and it's really important. So you have the idea what is a security, what is a utility, and how you must be careful. In the practice, we see, for instance, I don't know, the marketing campaign can be really dangerous, and how you sell your project can be dangerous. So be careful to attract people. It's important, of course, to have a base, but it can mean that your token become a security token. So about our team Storm partner, we are a legal consulting firm. As you can see, we are assisting clients in various matters. We can basically cover everything, I believe. Metaverse, tokenization, ICO, non-fungible token. In addition, we can draft contract. We can also help you, I don't know, give you some advice to create an entity. We have a legal team, but we have also a finance and fundraising team and a marketing team as well. We can assist you into your digital transformation, and we can provide some education and content, and we are organizing here at Decentral House some events. So we are really, the idea of Storm Partner is to give you some advice in the legal area, but also to give you advice for your project, so you can grow up, and we help you to be successful. So here you can see in the legal team, we are 4 people, and we have also a new joiner that recently come into the company. So now we are 6 people, we are growing. And you have here Nicola Massella, who is the head of the legal and compliance department. Rocco, who is the manager as me, like me, and we have our paralegal, Justin. So I think that's it. Let me know if you have some question. It will be a pleasure to answer to them. I try to simplify the topic, but I know it can be quite complex. But if you have a question, do not hesitate. Or as I mentioned at the beginning, you can even contact me later or the team to discuss a specific point or talk about the potential business assistance that you will need. No one has a question? So perfect. Thank you very much to listen to me, to have been here. Thank you to watch this if you are watching this later. And I wish you a great day. Thank you very much.
Thank you, Matthias.
Thank you.
Thank you.